presentation today. Thank you for joining this presentation today, and let's get started. Hopefully I won't scare people too much with some of the things that I might say today, but the whole goal is to make sure that you guys are running your practice ethically and efficiently. So let me share my screen. Okay. So we are here today to talk about ethics and elder law, how to run your practice ethically and efficiently. Today, we're going to discuss top ethical problems facing lawyers, provide some real examples from some published cases prosecuted by the Florida Bar, give you some tips and practices for how to avoid these problem areas, and to provide you with some helpful resources. So some of the top ethical problems that lawyers tend to face are safekeeping client property, which is governed by Chapter 5 of the rules regulating the Florida Bar, fees and costs for legal services, billing and account management, conflict of interest, communication and neglect, candor, and subordinate lawyer and non-lawyer staff supervision, how to deal with the departing lawyer, and finally, file management. What do you do with all these files that you've collected over the years? So one of the biggest things is safekeeping client property. As you probably are all aware, that this is one of the biggest major no-nos that you can get in trouble with from the Florida Bar. So the first thing you should do is to know and understand Chapter 5 of the rules regulating the Florida Bar. Chapter 5 is pretty much just two rules, 5-1.1 and 5-1.2, but it's very full of information that all lawyers should know, especially if you have a trust account. You need to avoid commingling. A lawyer shall hold funds in trusts that are separate from the lawyer's own property, funds and property of other clients or third persons that are in the lawyer's possession in connection with the representation. The lawyer should also avoid conversion, which is temporarily or permanently use of trust funds, as we all know, is considered to be theft. And the presumptive sanction for conversion is disbarment. If a client pays a set fee, which is an earned fee, and advance cost in one payment, that lawyer must initially deposit those funds into their trust account, and he immediately move that fee, preferably, of course, if it's a check, once it clears your bank account, to their operating account. The advance costs remain in the trust account until, of course, they are used. And any disputed funds must remain into your trust account until this dispute is adjudicated. And that adjudication doesn't necessarily mean a court-ordered adjudication. You can come to some other sort of resolution, such as mediation or by some stipulated agreement as to the ownership of the disputed funds. Funds held in your trust account should be there for a short term. And sometimes at the end of the case, you might not be able to find the client, they've moved, you no longer have the current address. So therefore, at that point, you need to follow procedures to sheet the funds to the state of Florida. You also need to make timely disbursements to your clients. So only disperse funds when they're collected as well. And when I say timely disbursements to your client, so if your client came in and you have funds that belong to your client, and you receive those funds, say today, December 16th, 2021, you need to try to make that disbursement as soon as possible so that you're not holding client funds that don't belong to you for a longer period of time. So preferably if you can, try to get those out by the end of the month, that would be great. But definitely don't hold them for 3, 4, 5 months down the line. Unless, of course, there's absolutely some particular reason why you have to hold the funds. You may be under a court order to hold funds for a particular period of time. So just be mindful about making timely disbursements to your clients. And the record keeping portion of the trust account rules highlight a few things. You must maintain your records for a 6-year minimum from the last activity on that particular client's file. So if your last activity was today, you have to maintain those files until December 16th, 2027, okay? You also must maintain client ledger cards, a separate ledger card for each client who has funds within your trust account. You also must, on all transactions, identify the client or case number on your checks in the memo area and in the memo area on online transfers. Sometimes people do transfers, wire transfers, or even if you're transferring those earned funds from your trust account to your operating account, there's a memo area where you can write that this belongs to Chardine Hill, for her probate case, okay? You also must maintain and keep a separate cash receipts and disbursement journal, and you also must do your monthly reconciliations. At any point, if there's anything that happens with your trust account, you can be audited by the Florida Bar, and the bar is authorized to go back 6 years into your trust account, okay? That's why the 6 years is there. All right. And rather, I guess a couple years ago, there was an issue that came out. And so the rules changed regarding if you have more than one lawyer in your law firm, you have to have what's called a trust plan. And that document basically outlines who's responsible for the actions regarding the trust account or trust account funds within that firm. Some firms, I know you guys have a pretty bigger one down there, that every lawyer basically at that firm has their little mini trust account that only that lawyer is responsible for, so that they don't run into issues as to, well, who does the bar go after if there's a problem in this particular trust account, okay? So that's what the trust plan is for. Again, if there's more than one lawyer in your firm, you must have a trust plan. That trust plan has to be provided to every lawyer in the firm so they know who's responsible. The best practice would be, if you at all possible, I know we didn't go to law school to be accountants, but to maintain your trust account yourself. If there are any shortages in your trust account, you have to report them, even if it's a penny, and you've put that money back. You must self-report any shortages to your trust account to the Florida Bar. If you assign that responsibility of maintaining and managing your trust account to another person, to an in-house bookkeeper, or even to an outside CPA, you are still ultimately responsible to supervise and oversee that the trust account is being maintained properly. Attorneys cannot abdicate or delegate to the bookkeeper or the CPA that ultimate responsibility for trust account maintenance. And the seminal case for that is the Florida Bar versus Russo and Roth, 117 Southern 3rd, 756. It's a Florida 2013 case. So if you're going to have a responsible trust account, basically you should review all your bank statements monthly, preferably, highly encouraged. Review your checks, review the signatures and payees, review your closing statements, review all your checks and balances for each account. And also make sure that you do not have non-lawyers as signatories on your trust account. The other thing that you should do when it's not on my slides, but definitely keep this in mind, if you have, of course, trust account and operating account, keep them in 2 separate locations. Keep your trust account in one location and keep your operating account records in another location. Also have different colored checks. So have blue checks maybe for your operating account and green checks or maroon checks for your trust account. If you have stamps that stamp the back of the checks with your account information on it and banking information on it, make sure the stamps are different colors on the outside so that you're not mixing accidentally which deposits you're making, which credits you're making, and things of that nature, okay? So some helpful resources for your trust accounts. There is a CLE that's available on the bar's website. It's called Maintaining a Trustworthy Trust Account. You also have some reliable software programs. A lot of lawyers and accountants like to use QuickBooks. And also, if you have a minor questions, you can also contact your local Florida Bar branch auditor. For this circuit, the 20th Circuit, the Tampa branch office is your local branch that covers the 20th Circuit. Next, we're going to talk about fees and costs. So before I flip to the next slide, how many of you have read the rules recently and know that there's definitions for a retainer, flat fee, and advance fee? I can't see your hands because you're all off screen. I'm assuming everybody knows. So let's review, make sure you review 4-1.5 in full at all times. It's constantly changing. Even little tweaks are being made. So just make sure you're aware of what the rule says at all times. Attorney's fees should be reasonable and cannot be illegal, prohibited, or clearly excessive. And those fees are those that are agreed to, charged, or collected. So you may have charged, say, $300 an hour, but you collected $500, what equates to $500 an hour. That could be considered to be clearly excessive, depending on the facts and circumstances of the case. You also must clearly communicate the basis and rate of your fee to your client. It's best to do this in writing to avoid any misunderstandings later. You don't want a client to come back and say, oh, well, I had no idea that, I had to pay Attorney Hill more money once I got to the trial stage. I thought this was for everything, throughout the entire proceeding. You definitely don't want that. So your best bet is to cover yourself. And you can cover yourself in writing by either having an engagement letter that you just clarify what your understanding is. It doesn't necessarily have to be signed by the client. I think it's best to also be signed by a client, because if you ever have to, CYA and protect yourself or prove something to the Florida bar later, or even in some sort of fee dispute, if you, get into a litigation with your client, you at least have that client's signature on the document. So you also need to know that a couple years ago, the bar decided to finally define a retainer, a flat fee, and an advance fee. These differences in the definitions will also affect where you deposit the funds. A retainer fee is not an advance fee. It's not a flat fee. It is simply a sum of money, and it's not to be used against legal fees, future or past. It's just a sum of money to secure the lawyer's availability. That's all it is. So those of you who still use the word retainer fee in your fee contracts, you might want to change that, especially if you're charging a flat fee or an advanced fee or an hourly rate or something of that nature, okay? I would suggest people call them engagement letters or fee agreements and get away from the word retainer agreement, because it now truly has a definition and you don't want to get caught red-handed with the Florida bar in case your fee agreement is called into question. I also suggest that you have multiple fee agreements for various services. So if you do probate work and you do summary administrations or you do full administrations, they might be two different fees for those types of cases. So have two different fee agreements for those. A separate fee agreement for estate planning, separate fee agreement for doing simple wills or complex trust. And definitely constantly check the language of your fee agreements to make sure that they're complying with the rules regulating the Florida bar. And when you use written and executed fee agreements or engagement letters, make sure that you're identifying the client. You're also stating the parameters of the representation and the fees and costs. Underneath Rule 4-1.2 talks about scope of representation. And if you can clearly delineate what that scope of representation is in your fee agreement or your engagement letter, again, it helps to protect you down the line. Be very clear about your fees and costs. Be clear if this particular fee is, taking the person to a certain stage of the proceedings, or if it's taking them all the way to the end. That also includes appeals. If you're going to appeal the case for some reason, state that there will be a separate fee involved if this case needs to be appealed at any point for any particular reason. Or if it's just an appeal of, if you're going to do minor appeals, interlocutory appeals, and then you just have a different one for end of the case appeals. You could do that as well, just depending on the nature of your practice and how you so choose to do so. Same thing with costs. If you're going to take costs, and cost advance payment for costs, specify that. Specify how you're going to be billing them. If you're going to, frequency of billing, monthly, bi-monthly, or if you're not going to send a bill until if you take an advance fee, once your advance retainer, sum reaches a certain level, then you'll send out a bill so that they can replenish the advance fee. Whatever the case may be, just be consistent with that particular client. I suggest being consistent throughout all of your cases so you don't get confused in the long run. And then sometimes we have third parties that are doing the paying. Just make sure that that third party understands that they are not the client. And this is for confidentiality rules. All you're doing is sending them the bill, collecting it, but they have nothing to do with the underlying the case, or have a right to understand or know what's going on with the case. So that also may include exactly what you're saying in your billing statements. You don't want to say too much when you're describing, the service that you did for that particular client if a third party is paying the bill, because you don't want to accidentally give out information, okay? If you have any sort of contingency fees, those must be in writing and have to comply with the fee guidelines underneath Rule 4-1.5F. And you also have to have the client sign a statement of client rights. And here again are the definitions of flat fees: a flat sum of money for all legal service for the representation. Usually it is earned upon receipt and is placed directly into the operating account. If you term it to be non-refundable, anything that you say is non-refundable has to be in writing. It doesn't necessarily have to be signed by the client, but it has to be put in writing that that particular fee is non-refundable. An advance fee must be deposited into your trust account and billed against as legal services provided and fees are earned. And again, the retainer is not payment for past or future attorney's fees. It's simply to guarantee that attorney's availability. And that amount goes into your operating account. Costs. Any costs that are charged must be actual costs. You cannot charge a flat rate of costs. So you cannot say copy costs $100 and for each client file when you didn't necessarily spend $100 for copy costs. You might have only spent 10 cents for copy costs. So all costs must be actual. If your fee agreement or engagement letter has a mandatory arbitration clause, Rule 4-1.5 has mandatory language, disclosure language that has to be included in your fee agreement. And it has to be bolded in all caps exactly how it is written in Rule 4-1.5. And also, if you have a mandatory arbitration clause before the client signs, you have to give them the ability, offer them the right to seek independent counsel regarding that clause. Okay. So let's talk about billing and account management. You want to send out periodic billing statements, again, usually monthly, show the balance of any funds that are in trust, advance fees that are in trust. You want to keep your time records for all types of fee agreements. Again, these things help defend against bar complaints and any quantum merit claims that may arise. Fees listed for attorneys and paralegals must be in your fee agreement, and they also must match the billing statement. Sometimes we like to give ourselves a raise. We like to give our paralegals a raise and other support staff that are working on there, or supporting attorneys, a raise. And we want to make sure that our clients are aware, that this raise has happened or this increase has happened. So say you're in the middle of a fee agreement with somebody and you decide to update your hourly rates. All you have to do is notify them in writing, say, here's an addendum to your agreement. As of this date, as of January 1st, 2022, attorney rates will now be $325 and paralegal rates will now be $175 from whatever it may have previously been. And keep a copy of that in the file. Again, preferably if you can get your client to sign off on that they understood and received it, that's perfect. Again, it's a CYA move for your part in the end if you ever should need it. But it's not mandatory that the client sign off on it, just as long as they are aware that there has been an increase and whatever you're charging in your fee agreement is exactly what it's being charged on your billing statement. And you cannot charge or bill for non-clerical, secretarial, or other non-substantive time. They should not be billed for. That's part of your overhead, no matter who is performing the task. So I'm a sole practitioner. I do everything. I do all my clerical, like take my mail and everything else. So I don't charge my clients, because I'm not allowed to, charge them for my clerical time or my secretarial time, or making copies and things of that nature. That's all part of my overhead. So how do you really get around that and say, gosh, well, that can be expensive? You hide it in your attorney hourly rate. That's where you do it. But you just don't charge separately for it, okay? And you also should maintain your time and billing entries with an explanation of your actions on the file. Again, just be mindful of confidentiality if you have a third party paying the bill. And when you're doing your billing, you cannot block bill. Block bill basically is if you're saying, I did 2.5 hours of research, responding to phone calls with opposing counsel, phone calls with the client, as the time spent on each task is unknown. So you need to, if this all happened on December 2nd, I can't just say 2.5 hours for all of this. I need to say I spent 1 hour doing research, 30 minutes responding to opposing counsel, and an hour talking on the phone with the client. You also cannot do unit billing. Unit billing is basically charging in increments, or saying if you only spent 3 minutes on a task, you cannot bill for 10 minutes for that task. So you can't just automatically assume that 20 minutes, for every phone call is just your minimum. And that was really discussed in the Florida Bar versus Richardson, 574 Southern 2nd 60, Florida 1990, where the court said, quote, there's absolutely no justification exists to bill for 20 minutes for every phone call or for a minimum of 45 minutes to prepare pages of the document without regard to the amount of time actually spent, end quote. This also came up in the Florida Bar versus Plonsky. And I have no idea why that doesn't have a Southern Reporter case to it, but the Supreme Court case number is SC 17-321. It's a Florida 2018 case. And here the attorney impermissibly blocked bills for time spent with the client. He charged full 8 hours when he only spent 5 to 6 hours with the client. And the respondent was the court said the respondent went out of bounds by charging the client for time that she did not even spend with him simply because he's not get any other work done for any other client. And we already talked about if there's a dispute of monies, it has to be held in your trust account until resolved. Conflict of interest. How do we manage those? There are various different sources of conflict of interest. They can be financial, professional, personal, or even sometimes your own prejudices. How do you handle them, and can any of them be waived? There are 3 conflict of interest rules underneath the rules regulating the Florida Bar. Rule 4-1.7 is conflict of interest with current clients. Rule 4-1.8 is conflict of interest business transactions with clients. And Rule 4-1.9 is conflict of interest with former clients. So Rule 4-1.7 specifically deals with prohibitions against representing multiple clients in a single matter. Rule 4-1.8 deals with engaging with business transactions with clients or acquiring interest adverse to a particular client. And Rule 4-1.9 deals with the prohibition against representing a new client against a former client in the same or substantially related matter in which that person's interests are materially adverse to the former client's interests. Oops. Sorry. I wanted to talk about a couple cases before I move on. So there are a couple of cases in this area that I think, especially for elder law lawyers, that you should be aware of. One is the Florida Bar versus Maurice, M-A-U-R-I-C-E, and that is 955 Southern 2nd 535. It's a Florida 2007 case. In Maurice, that attorney received a 90-day suspension in her connection with her handling of a probate estate. The attorney had prepared a quitclaim deed for her client, which transferred ownership of her condo to her son and grandson and reserved a life estate in the condo to the client. The attorney subsequently prepared a new will for the client, which bequeathed the condo to the son, the grandson, and the grandson's mother, and also included the provision that the heirs sell the condo to the client's caretaker. When the client passed away, the heirs retained the attorney to probate the estate. The attorney failed to advise the heirs that probate proceedings were unnecessary as the quitclaim deed made the heirs owner of the condo. The attorney's unnecessary opening of an estate placed her in conflict with the heirs, and the attorney's judgment was clouded by her concern over the caretaker. This attorney was ordered to complete several CLE programs and attend ethics school. The attorney was found guilty of violating Rule 4-1.1 competence, Rule 4-1.3 diligence, Rule 4-1.A communication, Rule 4-1.7B conflict of interest, Rule 4-3.2 expediting litigation, and Rule 4-8.4A misconduct. In mitigation, the attorney did not have a prior disciplinary history. Another case is the Florida Bar versus Brian Doherty. That's 94 Southern 3rd 443. It's a Florida 2012 case. And by court order dated March 29, 2012, Doherty was disbarred for conduct involving ethical violations that occurred during Doherty's representation of an elderly client to whom he provided both legal and financial investment services. Doherty was found guilty of violating the following rules regulated in the Florida Bar: 4-1.7A2, which is conflict of interest for current clients representing adverse interests, and 4-1.8A, conflict of interest prohibited in other transactions by having business transactions with or acquiring interest adverse to the client. In addition to his own law practice, Doherty had a background as a financial advisor, and he provided financial planning and investment service to clients. He was disbarred for engaging in an egregious conflict of interest and for failing to make specific written disclosures of his financial interests in the course of rendering estate planning services and brokering the sale of annuities to an elderly, terminally ill client. Although the sale of annuities was never completed, Doherty stood to have acquired a financial interest in the annuity transaction by earning a commission if the sales had gone forward. Shortly before the client's death and at Doherty's counsel, the client made several changes to her estate planning documents. A new will was created, appointing Doherty as a personal representative. 2 trusts were also created, appointing Doherty as a successor trustee. 1 trust required the proceeds generated from the sale of the client's home to be utilized in purchasing annuities at Doherty's sole direction, creating an opportunity for Doherty to churn annuity sales in the future. Doherty did not have any applicable mitigating factors. In aggravation, he had a prior disciplinary history. He acted with a selfish motive, refused to acknowledge the wrongful nature of his conduct, had substantial experience in the practice of law, and had submitted applications for insurance policies containing false statements. If you've ever had to deal with the disciplinary process or you were a member of the Board of Governors, you know that there's something called the Florida Standards for Imposing Lawyer Sanctions. I like to call them it's like the sentencing guidelines, if you will. So the Doherty case is actually now included in the Florida Standards for Imposing Sanctions as an example to support disbarment under Standard 4.3 for failure to avoid conflict of interest. And there's another case that your very own Amy McGarity served as one of my expert witnesses in, and that is the Florida Bar versus Daniel Plonsky. And that is SC 17-321. Again, I'm not sure why there's no Southern Reporter information, but by court order dated December 5th, 2018, after considering the reporter referee's recommendation of a 90-day suspension with a public reprimand before the Supreme Court of Florida, attendance at fee arbitration, and requiring to retake and pass the ethics portion of the bar exam. Considering the briefs and the record, including the bar's request for a 3-year suspension, the court issued an order directing Plonsky to respond to an order to show cause as to why the referee's sanction should not be disproved, and a more severe sanction up to including disbarment should not be imposed. On its own motion, in the interim of considering this, the court suspended him until further order of the court. They also ordered him to sign a fee arbitration agreement within 30 days of the order, agreeing to participate in the fee arbitration program with the Florida Bar with his former client, and to be bound by the decision of the arbitrator as to any excess fees that were collected from the client. While representing an elderly widow in an estate planning, Plonsky drafted a durable power of attorney, appointing himself as the client's attorney in fact. He subsequently prepared a revocable living trust which appointed himself as co-trustee and appointed his brother as successor trustee. Thereafter, he engaged in serious conflict of interest, including unilaterally loaning $75,000 of his client's money via an unsecured promissory note to his brother's company without first obtaining his client's authorization and without her knowledge. In total, he charged his client $124,750 in fees for the services provided and paid himself from her funds, which consisted of both legal and non-legal, or as he termed it, concierge services, over a 2.5-year duration during which he represented her. He also block billed his client, charged 8 hours even if he only spent 5 hours with her, and he failed to clearly explain the basis and rate of his fees to his client, failed to delineate those fees in writing, and did not provide her with any detailed invoices to substantiate his fees. He had no prior discipline. Ultimately, I can tell you he received that 3-year suspension, and there was a subsequent case and he is now disbarred. Okay, moving on. So the conflict of interest rules require certain disclosures that are made to the client or former client. And underneath both rules 4-1.7 and 4-1.8, the client has to give written informed consent in writing, signed by all affected persons after being explained the risk involved and given the opportunity to consult with independent counsel. There are special types of conflicts that also can arise, lawyers related by blood or marriage, gift to the lawyer or the lawyer's family, financial assistance to a client, compensation by third parties, settlement of claims for multiple clients, and limiting liability from malpractice, and of course, acquiring propriety interest in a cause of action such as a book or TV deal. Let's move into communication. When you are first meeting your clients, you should use a client intake form. Make sure you know who all the parties are and how the client was referred to your office. Find out if you had any prior representation regarding the case, do some conflict checks prior to the potential client's appointment, or, if possible, before you begin your consultation. If you're not able to do it right then, definitely immediately do it as soon as your consultation has ended, before agreeing to take on any representation, because you don't want to accidentally conflict yourself off or get involved in a conflict of interest situation, should there be one. If you charge a consultation fee, make sure that potential client is aware of it before the consultation begins. Be sure at any point do not guarantee results. Again, define the parameters of the representation. And if you have any lawyers in the room with you while you're doing that initial interview, their role should be limited to factual information gathering only. If you decide not to take the case, you should use a declination letter. So if there's contact with that particular client and there's no representation is going to result, send non-engagement letters. Tell them, the general type of matter, that no representation exists. Explain that the declination does not necessarily mean that they don't have a case. It's just that you are not willing to represent them in that particular matter. Encourage them to consult with other attorneys. And if you are definitely aware of any potential statute of limitations issues or any other critical deadlines that might affect the client's rights, please state those as well. And you should also cross-reference your calendar with client matters. List your scheduled meetings and hearings on the client calendar and your client file to double check to make sure you're not missing something. Something that I saw repeatedly when I was bar counsel is people would have, their notes in their file that says, oh, there's a hearing on this case, but it never made it to their calendar. I have 3 calendars, well, technically 3. One's on my phone, one's of course in the office, and then I have my paper calendar. In case technology decides to fail me, I have it in paper form, just in case. The rules regarding regulating the Florida bar require you to keep your client reasonably informed about the status of their representation, about any offers of settlement. It's best to spell out the communication guidelines in your engagement letter or your fee agreement, consider what's reasonable. What's a reasonable time to respond to your client? And how do you respond? If a client calls, call them back. If there's no answer, then leave a message. And I also suggest following up in some sort of written communication. So if a client calls me, I call them back, they don't answer, I then tend to send a quick email saying, hi, client X, this is Ms. Hill. I attempted to reach you on this date. Please give me a call back at your earliest convenience. Again, why is it important to keep a follow-up in writing? It's the CYA move in case you ever need to defend yourself against the bar grievance. If you email, of course, email them or call them back. Again, try to keep some sort of record. Call logs are also good to use as well. Document everything. Keep a communication log with your phone calls, your emails, any client visits that happen in person, the date, the duration, the purpose of that visit. It doesn't have to be a lengthy purpose, but just enough so that it can trigger your memory as well as the, if necessary, down the line. Communicate with the client promptly, respond and document your communications. Be careful with what you say in emails and text. Don't assume that it will remain confidential. Be careful about your snark, be careful about your wit, or something else you might say, because it might seem funny to you, but it might not be funny to the person on the other end or who they may show your messages to. And also sometimes these emails and text messages can end up in litigation. So definitely be careful with what you say. If you are a texter, I am not, I don't like for clients to text me, but if you are, have a way for you to be able to save those text messages to your client file. Make sure it captures the date, the times, and the sender info, such as their name or their phone number. Again, this is for CYA in the future. One of the other biggest areas is neglect. You've taken on a client, you've got a lot to do, or something may happen in your personal life that caused you to not be able to give the proper care and attention to your cases as you may want to. So Rule 4-1.3 says, the comment to the rule says a lawyer's workload must be controlled so that each matter can be handled competently. Perhaps no professional shortcoming is more widely resented than procrastination. Rule 4-3.2 says that a lawyer must make reasonable efforts to expedite litigation. Delays should not be used merely for convenience or to frustrate the other party. Neglect is technically not, you won't see it in a rule written that way, but it's a combination of lack of communication, lack of diligence, and sometimes includes lack of competence. It also includes the abandonment of a law practice. So you hear, and I'm sure you guys have read in your Florida Bar News, I can't find this person, so-and-so hasn't been able to be found. I don't know, I've been trying to find my lawyer. The bar will consider that to be abandonment of their law practice and then try to, find others to take on the case or appoint an inventory attorney to assist out. Moving locations and not telling your client. If you're going to change offices, if you change your contact information, you should put out a notice to your client. You can, create a quick postcard, create a quick mailer, definitely post it on your website if you have one. Include it in your email signature block. At effective, XYZ date, we will be moving to a new location. Keep it up in your email for a period of time so that in case you haven't emailed that client in a while and then you do so later, you have the availability to say, see, this email said we are now at this new location. Neglect also includes failure to follow court deadlines, discovery deadlines. So be sure that you're kept abreast of what all your deadlines are in your cases. And competent representation includes understanding the relevant and applicable laws, knowing your time limitations, and knowing of any pre-suit requirements, and definitely filing meritorious claims. If you are don't feel as if you're competent in that area, the bar rules actually charge you with either getting up to speed in that particular area or consulting with someone who is already up to speed in that area. And as you know, if you decide to bring somebody else on as an additional person in the case. Florida does not have what's typically called the referral system, referring a case to another person and getting a percentage of the fee. A lot of people like to say, hey, I refer this case, where's my referral fee? Florida does not have that system. Florida has a system of you become co-counsel. So if you refer somebody and you want to stay involved in the case, then you become co-counsel on that case. That other person may take 75% of the work, you do 25% of the work, but you remain, on the case. If you just want to completely get rid of it and send the person off to somebody else, you do so, you thank the person, you go have a cocktail or a meal sometime as a thank you. But you really should not be taking a fee from that person for referring a case to you. Candor. Honesty, trustworthiness, your integrity is essential in the practice of law. A lawyer's word is his or her bond. There are several different candor rules under the rules regulating the Florida bar. Rule 4-3.3 is candor towards the tribunal. A lawyer cannot make false statements of fact or law to the court, fail to disclose material facts, assist in crime or fraud, fail to disclose controlling legal authority, or permit any witness, including criminal defendants, to offer false evidence. A lawyer who later determines that material evidence is false must take reasonable remedial measures, including witness not to present false evidence, urging the witness not to present false evidence, withdrawal, or having an in-camera disclosure to the court. Rule 4-4.1 discusses truthfulness in statements to others. A lawyer cannot knowingly make a false statement of fact, material fact, or law to a third person. A lawyer cannot fail to disclose a material fact to third persons when disclosure is necessary to avoid crime or fraud by the clients. And Rule 4-8.c is a lawyer shall not engage in fraud, dishonesty, deceit, or misrepresentation. This covers the court, clients, opposing counsel, and to the bar or other disciplinary agencies. We already talked about the Doherty case, and remember one of the comments I made is that he made false statements in his insurance applications. So he was deemed for 484C as part of his dishonesty. Supervision of subordinate lawyers and non-lawyer staff. Some of us have it, some of us are like me, you just run the ship all by yourself. But if you have subordinate lawyers or non-lawyer staff, the managing lawyer has the ultimate responsibility over everyone. Everyone in your staff, whether they are subordinate lawyers or non-lawyers, are bound by the rules regulating the Florida bar. You must make reasonable efforts to ensure that your firm has in effect reasonable assurances that all lawyers in the firm conform to the rules. But there's some caveats. A subordinate lawyer does not violate the rules if that subordinate lawyer acts in accordance with reasonable reliance on the supervisory lawyer's reasonable resolution of an arguably question of professional duty. The supervisory lawyer is responsible for another lawyer's actions or non-lawyer staff actions if that supervisory lawyer gives an order or with knowledge ratifies the conduct of the subordinate staff or non-lawyer or subordinate lawyer or non-lawyer, or has direct supervisory authority and knows of conduct at a time when the consequences can be avoided or mitigated, but fails to take remedial action. You also, as the supervisory lawyer, need to ensure that your non-lawyer staff maintain client confidentiality as required by the attorney pursuant to the rules. So they can't go out and say, oh, Ms. Hill came in our office today. She's going to file a JQC complaint against Judge X. And she came to our office for our help. Do you know anything about her JQC complaint against Judge X? Talking to friends at a dinner table. The non-lawyer staff cannot do that. You need to make sure that they are aware that they have to maintain client confidentiality at all times. Do not permit non-lawyer staff to negotiate settlements. Do not permit your non-lawyer staff to discuss and or interpret the terms of your fee agreement with the client or the prospective client. Do make sure that you ensure that your non-lawyer staff explain to the client that he or she cannot provide a legal opinion or provide legal advice. And both attorneys and non-lawyer staff should explain to prospective witness that you are not disinterested in the matter. So if you are calling a prospective witness, you can't get on the phone and say, "Hi, my name is Chardine. I'm calling about John Smith. Can you tell me if John Smith has any children?" Because you're trying to find out who the heirs of John Smith are. You're not disinterested in a particular situation. So you should explain, "Hi, my name is Chardine. I'm an attorney at CMH Law and Dispute Resolution. I am calling to discuss John Smith with you. We are trying to locate the heirs of John Smith. Do you know if John Smith has any children?" Okay, that's what you should do. And there are a couple of ethics opinions that discuss subordinate lawyers and non-lawyer staff. And these are the ones on the screen. Ethics opinion 71-39 and 86-4 talk about non-lawyer employees can be listed on firm letterhead and business cards if the non-lawyer status is disclosed. Ethics opinion 87-11 says that non-lawyer employees are prohibited from signing the lawyer's names to pleadings or other court documents. Now we deal with e-filing. How do you deal with that? The attorney should still sign it. The non-lawyer staff can file it, but the attorney still needs to sign their name to their own pleadings and other court documents. Ethics opinion 74-35, non-lawyer employees are prohibited from engaging in settlement negotiations with adjusters. Ethics opinion 76-33 and 76-38, lawyers are prohibited from including non-lawyer employees in overhead and also billing for those same services. Okay, we talked about that earlier. And then ethics opinion 02-01, non-lawyer employee bonuses based solely on the number of hours worked is prohibited, but may be used as a factor to decide if a bonus should be paid and what amount. Next, let's talk about the departing lawyer. Sometimes lawyers want to change firms. They want to grow, or sometimes you might want that lawyer to leave your firm and you're like, "Whew, good, I'm glad they're gone." But what do you do with them? Rule 4-5.8, which was codified before the case actually happened, but the case seminal to this is Florida Bar versus Winters and Yonker. But the rule actually was codified before the case finished, the bar case finished. And it's applicable while the attorney is still at the firm that he or she is leaving. Once that attorney is gone, 4-5.8 does not apply. So if the attorney tells you today is Thursday, you know what, I can't do with you anymore, I'm done, I quit, and they don't come back anymore, 4-5-8 doesn't apply. But if they tell you today, you know what, I think on January 3rd, I'm ready to hang my new shingle. So I'm giving you my notice. January 3rd will be, or December 31st will be my last day. January 3rd, I'll be opening my new practice. Then you need to deal with 4-5-8. So 4-5-8 basically states that there shall be no unilateral contact with the clients by the departing lawyer, unless bona fide negotiations for a joint letter has been unsuccessful. The negotiations are in writing and there's been a reasonable time to respond. So usually the joint letter is a letter that says, Chardine will be leaving the firm. She's going off to XYZ location. You are a current client of firm X. You can either remain a client of firm X, go with Chardine to her new firm, or you can choose a complete firm. It's your choice. New firm all on your own, it's your choice. Please let us know what your decision is. If you and your departing lawyer are not in agreement or those negotiations break down, then that departing lawyer can contact the clients on his or her own without you being involved. But the best bet is definitely to try to get that letter out as soon as possible. The more time you know that the person is leaving, the easier it can be to, get that letter out and get that contact out to the clients so they can make the decision. But when you have a tighter window, it does become a little bit more time what am I trying to say? It becomes a little bit more pressing for you to get that information out. And so if it's unsuccessful, again, the lawyer can have unilateral contact. They can provide their own notice that the lawyer is leaving. And again, whether the unilateral contact or a joint letter, the same option still must be given to the client. They can remain with the firm, they can go with the departing lawyer, or they can hire another attorney. Any non-responsive client to the joint letter or the unilateral letter is presumed to be a client of the original firm. File management. Nobody's office looks like this, right? You should create a file organization system. Use some checklists for managing your case deadlines. Have a pleadings index, or communication records and logs, time entries and billing logs, your discovery logs, research section, and anything for miscellaneous. Maintain and utilize your calendar, use to-do list or a tickle system, and consider case management software options that may be helpful in this particular area. Again, if you have any settlement offers, relay those in writing, and when possible, get your client's authority to settle in writing. Document the files as much as you can. Copy the client with all relevant documents related to the representation, and provide periodic updates. And those periodic updates can even include, there's still nothing going on in this place. I just wanted to let you know I haven't forgotten about you, but there's nothing pressing right now going on in your case. But, we're still keeping an eye out for anything that may come up. Conduct periodic file reviews to maintain progression of your files. And I cannot overstate the importance of documenting all of your activities on your client files. Again, it's a CYA type of issue. Create a procedure for file retention. It can be physical storage, electronic storage. Determine what your firm will keep, what will go back to the client. There's no particular set rule on how long to retain a file. However, keep in mind the 6-year retention for your trust account records. So it's my suggestion, use that same 6-year retention for your client files. And again, don't forget about confidentiality when you're destroying client files. Please don't take it to your local Target and dump the files in the trash can. And if you're have a shredding company, make sure that it's a trust and reputable company that's actually going to shred your files for you. If there's something that the statute or rules don't require or don't allow to be kept electronically, and you have to keep the original document, then make sure you're keeping the original document, okay? All files have to be readily reproducible and protected from inadvertent modification, degradation, or destruction. Current files that I mean active files. If you have any originals, it's best to make copies of those and send them back to the client if they are not needed to be maintained by the lawyer. I suggest you send them certified or something that's going to require a signature from the client, or have the client come in and keep a signature receipt for the documents that are returned. Whenever your case is over, only keep the final version of a document. Why do you have those drafts? Get rid of them. I know why you have the drafts, because you really don't like to type over and do things from scratch. That's when you keep templates, create templates. So the templates essentially is take out all the client identifying information, take out their name, take out the case number, take out any particular, children's information or whatever that could be linked back to the client, and just keep the crux and the meat and potatoes of the document. You don't need to keep the entire draft. Just keep the final version, if any, and delete your drafts, because they can be subject to discovery. They can be subject to discovery by the Florida bar or by an opposing party in any particular litigation, okay? Again, send your disengagement letters or her closing letter to a client when the representation is over. It can include deadlines for the right to appeal, especially if you're not going to be the one taking on the appeal, and the need to consult with separate counsel for any appeals that may be needed. Outline your policy for destruction of file. It might be a good time to market yourself, for future availability of different representations, or, to ask them to refer you to others they may know that might need your assistance in the future. So in general, to avoid or minimize a bar grievance, know and review the bar rules. Rule 3-4.1 charges all lawyers with knowledge of the rules and their amendments at all times. So the excuse of, well, I didn't know that was against the rules, doesn't apply. And I will probably also tell you that saying, well, I didn't know that was in a Supreme Court case or a bar case, that's not going to cut it either. As to saying, well, you weren't aware. You should be aware of what regulates our profession, whether it's in a bar rule or in controlling case law, which is Supreme Court cases from the Florida Supreme Court. Remember the importance of maintaining client confidences both during and after the representation has been completed, and advise your non-lawyer staff as well. Keep supervision over your non-lawyer staff and your subordinate lawyers. Have clear-cut policies and procedures. Consult with your lawyer with experience in the area of lawyer ethics or bar rules if you have any questions, and make the ethics hotline your new best friend. If necessary, request a written ethics opinion and keep a log of all your calls to the ethics hotline. They keep a log too, but they don't always, and I'll tell you, in trying to get from ethics hotline to say, hey, I'm investigating this attorney and they said they called the ethics hotline. Can you tell me when they call you? Nope, we can't tell you. So the ethics hotline won't even tell bar counsel if you called, but if you kept your own log, we can then cross-check that, and then they'll be able to tell us, or they'll verify with you, yeah, we have a call with you on that particular day, but they will not essentially, I like to say, snitch on you and tell us that or tell bar counsel that you called them for assistance. And last but not least, here are some helpful resources for you to help keep your practice running ethically and efficiently. You have the bar's website, which has various rules, ethics opinions, and access to CLEs. You have Legal Fuel, which has guidelines for running a law firm, sample trust account management forms, also has some various free CLEs and podcasts. You have Ethics Hotline. There's the phone number. You can obtain written ethics opinions if necessary. And I will give you a caveat about Ethics Hotline. Ethics Hotline only covers prospective conduct. So if there is something that has happened in the past, Ethics Hotline is not going to answer your question. Of course, there's a trick around it, is to ask your question as if it hasn't happened, but definitely it deals with prospective conduct. Florida Lawyers Assistance, or FLA Inc. There's their phone number. They also have a website, but basically this helps attorneys with substance abuse and mental health issues. If you go to FLA on your own accord, FLA is like an employee assistance program. They do not share that information with the Florida Bar. If you, of course, are sent to FLA through a Florida Bar's diversionary program or part of your the grievance process, then they will share information with the Florida Bar as far as, you're in compliance with your contract and things of that nature. They don't share everything, just compliance, whether you're not in compliance and things of that, okay? Then, of course, you have your Florida Bar News. So the cases that I read off earlier and gave you some information about, at some point of another, they all made it to the Florida Bar News. There's routinely a section that discusses ethics and bar grievances and outcomes. And there's also a list of lawyers that are versed in ethics in the bar grievance process that are usually also in there, usually underneath the attorney exchange section. So if you need someone to call, they are listed there as well. And that concludes my presentation today. Does anyone have any questions in the chat while I stop my screen?
It's John Lonergan. I've got a quick question if we're allowed.
Sure.
I've got 3 of them, really. But I'll try to make it quick. You said on billing, send them out monthly, which we do, but when they're flat fees, I only send it out at the end of the case. Do you think that's okay?
If it's a flat fee, and have you told them in advance that it's a flat fee as well, right?
Yes, it's a flat
Okay.
fee and it's a minimum fee.
Okay, so then at the end of the case, that should be fine. If it's
Okay.
billing and you're billing against, or charging them monthly, then it's best to send out your bill, monthly.
Okay.
Try to do it at the same time. It doesn't always happen that you can do it at the same time every month, but if you can,
Okay.
that happens.
Second question, we don't do this in our firm, but I'm like you, I'm a sole practitioner. My wife and I work together. She's assists me. But there was a firm in a family law case where you said you can't bill for clerical or secretarial time, but the attorney firm, their clerical staff and secretarial staff were actually billing the client. So when I was reviewing bills in an attorney's fees hearing, there was a 0.1 by their receptionist to take a message. Is that allowed?
No.
Okay. Is there a rule or something that's clear on that? Because
Let's see.
so even if it's not the attorney billing, the clerical staff can't bill. Okay.
Correct, because the clerical staff is part of your overhead. So you can't bill for that. They should be wrapped into the overhead. And like I said, the trick to get around that is to increase the attorney's fees because essentially, they're getting a paycheck.
So we need to tell Amy not to do that anymore. No, just kidding, Amy. Just kidding. Okay, I won't.
I know Amy doesn't do that. I know.
No, I'm kidding. Okay, and the last question I had, and this has to do with my client in a divorce. She hired me, but she went to another attorney prior.
Mm-hmm.
She consulted with him an hour. She decided not to go with him. Her husband hired him. So I filed a motion to disqualify, and he said that there was no conflict due to this is quote now, no confidential information being provided to him, that the meeting with her was brief, and she paid him money, by the way, that the meeting was for informational purposes only, and then the information was provided by her was factual in nature and either known or easily discoverable by the husband. Now, that language, I quoted that because he pulled that out of one of the cases that says, now my question is, how on earth, now the judge did disqualify him, but how on earth can someone do a consultation for an hour, receive money, and say they never received any confidential information? Isn't there a presumption that if you consult with a prospective client that it's confidential?
4-1.8 talks about confidentiality with a prospective client, and it also talks about those who may be shopping around to try to get a lot of different attorneys conflicted off so that the other side can't get fair representation. So that's Rule 4-1.18 that talks about prospective clients. But generally speaking, that the duration of an hour, if you really sat for an hour, would lead me to think that no more substance should have been there. If it was maybe a 5-10 minute conversation, I'd be more inclined to think that you couldn't have shared a whole lot of substantive information.
Well, fortunately, the judge had been a family law attorney, and so she said when she consulted, she knew what people said. It just was kind of interesting when he said that, and while the court didn't buy it, and I read the law and stuff or the rules, but it was hard because they talk about clients and not prospective clients. Mm-hmm. And so I wasn't really sure on that, but
yeah. Okay. So the prospective client rule is 4-1.18, and it does talk about confidentiality with prospective clients in there.
Okay, thank you.
Mm-hmm. You're welcome. There's a comment in the chat from Danielle Clark. It says, can a legal assistant bill for their time? Is this legal assistant also a paralegal? No. So they're just straight a legal assistant. So basically office non-lawyer staff. And the answer to that question is no. They're part of the overhead of the firm.
By the way, excellent presentation.
Thank you. Are there any other questions? Going once? Going twice? Well, I'd like to thank Amy and Lauren for inviting me and having me to speak with your Lee County Bar Association today. And I hope everyone enjoyed the presentation. If you have any questions, feel free to reach out to me. I am pretty much available almost Monday through Friday. I love my weekends.
Thank you so much. That was an amazing presentation. I hope everyone enjoyed it as much as I did. And with respect to your CLE certificates, I will be emailing those out. For anyone that would like to have this presentation on hand, I will send you the YouTube link, as it will be forever on our YouTube. Thank you very much, Ms. Hill. We really appreciate your presentation and your time.
Lauren, how about the presentation of the materials? Are those going to be provided?
I can provide those to Lauren and so that they can be accessible. It'll be in a PDF form, but I'll provide it to her.
That'd be great.
Thank you. All right. If no one has anything else, I'm going to go ahead and end our meeting. I really appreciate everyone attending. Have a great holiday.
Thank you, everyone.